Okay. All right. Well, welcome everyone. I don't know how many webinars we've run so far. This is probably about our 10th, 9th or 10th or something. And very much looking forward to our topic and our speaker today. Thank you for joining us. I'm assuming all of you are familiar with Funeral Consumer Society, that we are a nonprofit organized around helping the funeral consumers of Colorado attain the knowledge and input that they need so that they can make educated decisions around their funeral planning, hopefully ahead of time, planning ahead. And if not, at the time of need, we're here to support you. Most of you probably know about our website and that there's a tab on the website that's our price survey, which is a great starting place for figuring out who's in your area. You can sort by city or by county, and you can see some basic information such as the pricing for direct cremation and who owns the funeral home or the funeral provider. We are very much supporters of privately owned funeral providers. Not to say that all corporate owned are evil, but they have a different way of being in the world, and we like to support the people that are going it as a family or as a smaller entity. Anyway, so today's topic is what happens when we don't get around to doing our estate planning. One thing I want to point out, and Cynthia will probably mention this, is that don't be put off by the term estate. A lot of people will say, well, I don't have an estate. I don't have $1 million house or, multiple investment accounts or whatever. Whatever you have is your estate. So it needs to be planned for, or as Cynthia is going to make very clear to all of us, that those decisions are made for us already. There's laws and systems in place to make those decisions for us, and they very much likely won't be the decisions we would be making for ourselves. So we'd like to be the ones in charge. Cynthia Doughtrey is a board member, fairly new. It's within the last year, I think. Cynthia, you came on the board for the Funeral Consumer Society. And we are happy to have her and her expertise as part of our group of volunteer board members, keeping this organization alive. A big part of which is putting these webinars on so that we are doing our mission, which is educating the funeral consumer public. Cynthia began her career as assistant DA in Milwaukee County in Milwaukee, Wisconsin. And in 95, she moved to Colorado. She's been a practicing attorney for 36 years here and has been practicing law in the areas of real estate, metropolitan districts, and water law, local government and contracts in private practice, local government, and corporate legal settings. Cynthia founded her own law firm in 2018, and currently she's practicing in the areas of estate planning, wills, trust, contracts, and real estate. Additionally, she's a licensed real estate broker in Colorado, and she's a member of the Colorado Board Association, the Northwest Colorado Bar Association, member of the Agricultural and Rural Law Organization, Business Law, Real Estate, and Solo Small Firm and Trust and Estates sections of the Colorado Bar Association. As you can tell, she's quite involved. And I didn't know this until I read her bio, is that in her free time, Cynthia spends her time in the sun as she's an avid road and mountain biker, skier, swimmer, and triathlete. Her most memorable triathlon was the completion of the Escape from Alcatraz. Who knew? She's also climbed and successfully summited Mount Rainier in Washington twice, climbed mountains in Ecuador, and reached the top of Mount McKinley, which is the highest mountain in North America at 20,000 plus feet. So we are lucky to have her, a multi-talented input today. I'd like to, as far as housekeeping goes or whatever, just let everyone know that I know questions are going to come up. what often happens with webinars is that your questions will get answered down the road further into the webinar. But what I'd like to invite you to do is, as questions come up, put them into the chat, which you'll see in the bottom bar of your screen. And I'll feed some questions to Cynthia if they seem to fit into what she's talking about. And then the last 15 minutes or so of the hour and a half we have until 5:30. So around 5:15, we'll open it up for live interaction. You can ask your questions directly of Cynthia, and we'll make sure we get through the last of the chat questions also. So sound okay? Any questions? I'm going to I have everyone on mute so that there's no distractions. And we'll open that up then at that 5:15-ish mark. I'm going to turn it over, the screen over to Cynthia. And you might want to pin her. You know, we can see like everybody on the screen, but if you would like to see her more lifelike, on the upper right-hand corner of her square, you can click the three dots and there a line will come up that says pin, and you'll be able to watch her more like you were here in person. Okay, Cynthia, take it away.
All right, thank you so much, Sue. Let me pull up the presentation. So let me figure out, I'm gonna have to put everybody way over to the side. It's not that I don't like you, but that way you can see my whole screen. So thank you, Sue, so much for that wonderful introduction. And I'm up in wonderful northwestern Colorado. That's where my practice is, in the small town of Hayden. And you're probably wondering, well, how on earth did she get a start in her practice? Well, believe it or not, I had a neighbor give me a call, and the neighbor said, "Hey, are you still practicing law?" And I said, "Yeah, I'm still practicing law." And this was November 2018. He said, "Well, we got to check on our attorney. I'll give you a call here and see what happens." So I said, "Okay, no worries. Just let me know." A half an hour later, he gives me a call, and they were actually doing a wellness check on their attorney. And he said, "Well, he's dead. Can you come in and interview for us?" And I said, "Well, not today, but I can come in and interview." So the next day I came in and interviewed. It was a company that did parkings collections and enforcement. They needed an attorney to review their letters before they sent them out for collections to individuals who didn't pay their parking bills. And that is how Buyer and Associates got started. And I was with them till June of 21. And then I decided to explore the other world, not parking collections and enforcement. It was interesting work, but my heart was really in real estate and contracts rather than in collections work. So that's how Buyer and Associates got started. So now you're probably wondering, um, what happens if you don't decide, if you can't figure out what to do with your estate or your will or what you've got left over? What happens? Well, in the state of Colorado, actually, the court is going to decide what will happen. So if you don't plan, there is a plan for you already. The legislature is taking care of that in its infinite wisdom in the statutes. So do you want to know what that is? Well, I'm going to tell you right now, you may or may not like it, just depending upon everybody's unique legal situation. If you're married, not married, have kids, no kids, don't like your kids, don't like your spouse, separated from your spouse, there's an answer for just about everything. So, and another question you may have is, well, what's probate and when does that kick in? And how does it actually work here in the state of Colorado? What's the limits on it? Do I have to go to court? Do I not have to go to court? And what does this all work from start to finish? We're going to cover all of that for you today to kind of give you that basic education of what all goes on. So,
Can I
yes.
just 1 second? Are you able to change move your screen a little bit so we can see more of you, because your name is across your face a bit?
Let me see. Hang on.
Or sit up on a pillow or something, I'm not sure.
Hang on. I'm going to sit on a book. I'll be right back.
Okay, sorry to interrupt, but.
All right. Hopefully this isn't too high. How is this? Is that better? Okay. The other question that we're going to answer today too is what if you need a guardian and what does that all mean? And then what happens if you need a conservator? And what's really the difference between a conservator and what is the difference between a guardian? So what is estate planning? So what it is, it's the process of preparing legal documents to avoid leaving your family a mess if something happens to you. That's really the short answer on it. And your estate plan can be comprised of different components. People will have wills. That's generally what you want to have. If you don't have a will, then you're considered when you pass away and if you have assets, you're considered intestate. And that's a whole nother batch of worms you don't want to get into. Some people will have a trust that's revocable or irrevocable, and we'll go into a little bit of detail on that. Another important component is a durable power of attorney, a healthcare power of attorney, a HIPAA authorization, and I always recommend also a living will. So what are each of these components? Well, typically your will is going to be notarized. It's your wishes of how you want things distributed. If you have a spouse, if it's going to the spouse. If you have children, if it's going to the children. The other thing that's always really important too, in this day and age, one of the things that we are starting to see more of, we're seeing a situation where children are being estranged from their families. And so some parents are taking the tact that, okay, if you don't want to have any communication with me, you're not entitled to what I have to pass down. And if that's the case, you want to make sure that you've got very specific language in there for disinheriting children. And then you also, within your will, can delineate the order of who gets what and who, how much they get and when they get it. And it basically determines everything that happens to your property, if it gets sold, if someone gets to inherit it, and what happens for the items that you're passing down to your children. You want to make sure that your will is notarized and that you have two witnesses for it. And then more than likely you have a valid will. So a power of attorney, this is a legal document that in the event of your incapacity, it designates an agent to handle your affairs while you're alive. Once you die, though, it is no longer in effect, and what you have for accounts needs to go through probate. So your power of attorney can be very broad or it can be very specific. For instance, I have one client where they wanted to have their daughter handle a real estate transaction. So for that transaction, they gave the power to buy and sell, invest real estate to their daughter. Some people with their power of attorney, we draft so that there are many powers and many duties that are passed on the um, to the agent for the power of attorney. For instance, the power to take care of insurance, to cancel insurance, the power to deal with real estate, the power to deal with security accounts, with your investment accounts. And one of the things that your attorney will go through with you is what's important for you to give that power to someone else to make sure that they can take care of your affairs. Generally, also within your power of attorney, what's going to happen, it will designate when it kicks in. Some people will turn it over immediately to a person because maybe they're fading and they want to make sure that they have um, that they have someone to take care of their matters. Another instance, they will say when they're incapacitated, and then you get to delineate when that is defined. Some people will have their attending physician make sure that that's the case. Other people might have two people, their attending physician and another doctor, or maybe it's the attending doctor and a spouse, or maybe it's an incapacity board. That's things that your attorney will talk through with all of you. And then there's a form that will be signed to make sure that you want that power of attorney to go over. You can also, within your power of attorney, you can designate who you want to be your guardian and your conservator. Because as we'll talk about later, if you don't have some type of designation for a guardian or a conservator, what's going to happen is then you're going to have to go to court. And that's when you're going to start to spend a lot of money because it takes a lot of money to get the expert witnesses in, to establish the incapacity, and to get the right people in there to represent you as your conservator or as your guardian. Another tool that people will use when they're planning their estate, and your estate can be as simple as I have clients that have a house and they've got their retirement accounts, and that's enough to set up for a trust. The advantage of a trust is when you have a trust, there are two types. There's a revocable living trust and an irrevocable trust. So the best way to think about it, a revocable living trust is like the open treasure box. You can put things in, you can take it out. The irrevocable trust is you can put things in, but once it's in there, it stays locked. You can't take it out back and forth. So that is the difference with the trust. The other thing with the trust, if you have a properly funded trust, those assets that are in the trust do not need to go through probate. And why is that important? That'll be important here in a moment when we talk about what types of probate are triggered, because there's two types of probate. There's formal and informal, and the difference can be pretty costly between the two. So the healthcare directive is another thing that you want to have in your estate plan toolbox, so to speak. What this defines what happens when you get sick or you're ill or you're incapacitated, how you want to be taken care of. We may talk about these things with our children or with our grandchildren or with our spouse, but during that time when you're in the hospital or your spouse is in the hospital, there's so much stress. And if you can talk through and have it written down exactly what you want to happen, it makes it so much easier for your family. Some of the things that you might include would be, do you want to have hydration? Do you want to have nutrition? Do you want to have pain medications? How much healthcare intervention do you want to have at that stage of your life? That can all be defined there within your healthcare directive. So you might be saying, well, why do I need a lawyer when there's LegalZoom? I can go on to the computer and talk to ChatGPT, and ChatGPT will tell me exactly what I need to do, and it's going to spit it out. Or you go into Claude Code and you say, Claude, make me a will, make me a power of attorney, get me that healthcare directive. And they'll go out and they'll bring it back for you. But the thing is, those artificial intelligence or LegalZoom where you have just the straight forms, it doesn't know your unique family circumstances. Is there somebody that needs to be excluded from handling your affairs or your children? Is there someone that you do not want to have as a personal representative because they've got drug or alcohol issues? Is there someone that you do not want to inherit because they have drug and alcohol issues? Is there someone that is just going to blow everything? Is there someone that's not really good with numbers? Because if they're a personal representative, you want to make sure that they're going to be okay with numbers and being responsible for getting the proper paperwork filed. And it may not put the right protections in place for you, whether that's doing a will or whether that's doing the trust. And it also protects your children's inheritance because some people have tax implications and some people don't. Right now, the federal estate tax that kicks in is when people have 13 million. Some people might get up to it and some people may not. But if you have above it, that is going to be an issue, and you want to make sure that you're doing adequate tax planning. I'm not a tax advisor. I don't play one on TV. So if you do have tax issues, that's another reason to talk through with your accountant as to what the implications are going to be on the inheritance and the properties and the accounts. Sometimes with retirement accounts, I believe it's 10 years that the accounts need to get, drained and used and moved over. So there's unique circumstances for everyone. The other thing that's really important is to get organized. Otherwise, you're leaving a scavenger hunt for your family. Well, what do I mean by getting organized? Do you have a list of all of your accounts, all of your checking, savings accounts, all of your investment accounts? Where are your passwords? Are they on a sticky note on your desk? Are they written down someplace? How about pictures? Where are your pictures? A lot of us have our pictures on our phone. And another thing that I'm seeing that absolutely drives me crazy is facial recognition. Or, do you want facial recognition to get into your accounts? Well, that's all fine and dandy, but when someone's dead, that facial recognition isn't going to work. You need an alternative methodology for getting in there. And the other thing is you need to make sure that you have the passcode and someone has that passcode to get into the phone. A lot of your investment accounts and checking accounts, etc., will have a two-factor authentication. And when they do that, typically it sends a code to the phone and that needs to get inputted to get into those accounts. So when you have that list of accounts, list of assets, it makes it so much easier for your family. Because otherwise, if you don't, then you're going to be paying the attorney to go looking and try to find where are all these assets. Now, an interesting thing for you to take a look at is I believe it's on the Colorado treasurer site. There's like unfound assets. I don't have the link and I forgot to stick it in here, but because I just thought of this, but it's kind of fun to go in there and see if there's an account that maybe you're owed money on. Another thing to keep in mind too when you're putting this together is on those retirement accounts to make sure you've captured everything. You may have worked in another state. So for instance, for me, I worked in Wisconsin, so I had a pension from the Wisconsin Employee Fund. But if I hadn't started drawing on it and talked about it with my spouse, they would never know that there's a stack of money sitting out there that would be part of our plan and that the family could have for assets. So why do you need this? So without that proper plan, your wishes are not going to be respected and they're not going to be honored. And this is your legacy. This is what you're passing down to your family. And so I know for me, it's important to make sure that my family knows what's the legacy and what's important to pass down. Because some of it too may not necessarily be the physical things, it's other things. So what happens if you don't have a will and you don't have a trust? Then what happens? So here is Colorado's plan if you die without a will or a trust. So the first situation is if there's no surviving descendants and no surviving parents, then your spouse receives everything. If all descendants are shared with your spouse and your spouse has no children from elsewhere, then everything goes to your spouse. If there's no surviving descendants, but a parent of yours is alive, then the first 200,000 goes to the spouse and 3/4 of the remaining balance. And then the rest would go to the parents. If all of the descendants are shared, but your spouse has children from another relationship, the spouse gets the first 150,000 and then 3/4 of the remaining balance. Now, why is this one kind of important? We're seeing a lot of second marriages and we're seeing a lot of mixed marriages where people have the blended families and they may not intend to exclude the stepchildren, or maybe they do. If you have that will or that trust, you can make sure that everybody's provided for. Otherwise, if there is none of that, then they're just going to be cut out of the picture entirely. So the very last scenario, if some of your descendants are not your spouse's children, they get the first 150, your spouse gets the first 150,000 plus half of the remaining balance, and then it gets split to the children. So another concept we're going to talk about today is what is probate and when does it apply? So probate is a legal process by which the property of a deceased person is distributed to the heirs. And it can be the heirs at law, which we just described. So that would be the spouse, it would be the children. It might be the adopted children, and it would also depend on if someone was pregnant, and if there's afterborn children. It all depends if that's defined within your documents. So the first one we're going to talk about is what's called informal probate. So informal probate, what that means is if you go on the Colorado courts page and look under forms, there are forms for probate. And for this, you can pretty much do it on your own if you just follow the forms. The courts are pretty good with helping people on that. When this applies is when there's no real property to distribute and that there is less than $86,000 in personal property, which would be accounts, retirement, IRA, savings, checking vehicles. The problem is everything that's there is a public record and everybody knows your business. Now, some people, a husband and wife might have their property held as joint tenants with rights of survivorship. In that situation, when one of the spouses passes away, the property goes automatically then to the other one. And that is not included. And that situation would go through informal probate, provided with the accounts that's there that it's all payable on death to the spouse. So if all the accounts transfer out right away, then you're going to be in the informal probate procedure. The problem is when the second spouse dies and you now have real estate and you may have all the accounts that are more than $86,000, then you're going to have to go through formal probate. So formal probate kicks in when there's real property to distribute. Again, there's more than $86,000 in personal property, and it's a public record, and everybody gets to know your business and what the heirs are receiving. So for some people, you may not want your children to be placed at risk of predators coming after them because they see they have a huge inheritance. Some of the property might be difficult to split up, might be difficult to sell. The other thing too with probate is if you have property in multiple states. So for instance, I have a client that they had property in Colorado and they had property in New Mexico. So the probate happened in New Mexico, and now years later, they realized that there were mineral rights that they needed to get distributed up here in Colorado. So now we're going through probate here to get those mineral rights distributed. So that's why it's really important to make sure you've got that list of everything that you have for all of the assets for people to make sure that you've got everything covered so you don't forget anything. So this might be a good time to answer any questions if people have questions.
Yeah, there's a couple, actually just one main question
Okay.
in the chat, which is what happens if you die intestate and you have no living parents or children or a spouse? Because not everyone has a spouse, obviously.
Do they have children?
No children.
Then it would go to trying to find who the heirs at law are. So then they start searching for those long lost heirs. So that might be if you have brothers and sisters, if they're still alive, if they had children, and then just keep going down to try to find, relatives that could then inherit at that point in time.
And how do they decide how that gets distributed then if you have siblings or nieces and nephews from those siblings plus aunts and uncles? Is there
It's
some?
going to go, so it really depends on the situation. So, um, if you don't have the will, if there's like one sister and one brother, it would get split between them.
Mhm,
Um, with if the sister's gone, but the sister maybe had, two kids,
mhm.
then maybe her share is split between the two kids, and then they get a quarter each, and then the brother would get half. But I I have not run into a situation where we've had to go digging to try to find those heirs. Typically, we've got heirs at law to that will inherit.
Okay.
But you
Some,
might want to, if you're in that situation, you you have a couple options. You can either try to track down those people, get that will done, and maybe you want to leave it to friends, or maybe you want to leave it to a charity. Those are options for people if they have no family.
so it's another good reason to make sure you create a will so you have say on where that cash goes.
Right, because some people, they may not have family, but they're very passionate about certain causes. My sister volunteers for it's VOC, Volunteers of Colorado, where they do trail building and other things. Thank goodness she's got a lot of brothers and sisters, and I helped her with the will, so I know we get shares of it. Otherwise, if she didn't, I could totally see her leaving it to the Volunteers of Colorado, or something else that's very near and dear to people's heart, like a conservation fund, or maybe it's the open space, like Jefferson County open space. So many things like that are available if people don't have anybody that they want to leave what's left. And it doesn't need to necessarily be a huge estate. Another thing that can happen too, and I help people with this, um, maybe you've got the old cabin in the woods, and it used to be where everybody went, but now all the kids are out of state. All of no family members use it anymore. So what are you going to do with it? So you could do a couple of things. With something like that, you could put in your will that it gets sold, and then the proceeds go um, to a charity, so you get a charitable donation on it.
Mhm.
So that's an option too for people.
All right. Quick question about, are cousins included in this, looking for heirs?
It would depend. Every circumstance is unique, and so I can't really address that. It would depend, and so I'll just leave it at that. That's why it's best to always check with your attorney on it to go through it.
Is there time here for a couple more questions before we move
Sure.
on?
Yep,
Okay.
let's take.
Um, yes, Susan's asked, I have a will in England for my assets there. How do I assign my assets here in the US? She lives here now.
Um, what you need to do is have a will for here in the United States, that can then go through probate, or if you want to do a trust for those assets, it depends what you want to do with them. If you know that, it depends on that value, because if you've got real property, keep in mind it is going to have to go through probate here in the United States.
So if you have property in England, it has to go through probate here if you die here?
No, it'll have to go through probate there,
There,
and then
okay,
you'll have to do probate here. So you'll have to do in both spots.
gotcha. And the last question I'm seeing for the moment is, how is incapacitated determined for medical power of attorney and financial power of attorney to kick in? So this is um, correlates to a question I was going to ask you to define the difference between non-decisional, which applies to MPOA, and incapacity for financial power of attorney. Have
It
fun with
depends. I'm going to tell you, it depends on your document, because when you draft your financial, your durable power of attorney, you define in there how that capacity can be. And typically the options that I give to people are, number one, your attending physician to say that the person's incapacitated. Another option that you could choose when you're drafting it is the attending physician and a spouse. Another one that people use is two doctors to make the incapacity decision. Another one that people might use is, quote, an incapacity panel. Now, the issue that you're going to run into with each of these is how do you get them all together to make that decision? So you need to talk through, it's important to talk through with with your attorney how you want it to operate and who you want to make that decision.
Okay.
So you also had another question?
No, I just wanted to clarify that having been on the ethics team at our local hospital, it's what applies for a medical power of attorney situation is the patient being non-decisional, which is different than incapacitated. So non-decisional means that they cannot understand the circumstances that they're in as far as determining whether they want a treatment or want to deny a treatment. They can't balance the benefits and burdens of a particular thing that's being proposed. And it's very situationally specific. And so that's non-decisional. And then I believe that for financial power of attorney, it's incapacity, meaning you can't manage your
Yes.
life, kind of thing.
Yes. You can't make, yes, it's a little different. Yes.
And I'm just going to jump in and say, just from my experience, that having a medical power of attorney form completed that says that you want two doctors or a doctor and a spouse to determine decisional capacity can turn into a nightmare in the hospital. The medical power of attorney form already reads, I want this person to make a decision and when I can't. So if you indicate, it sounds like it makes sense that you would want it to be, for sure that you're determined non-decisional before your power of attorney can step in, but it can really bog things down and you could be sitting there waiting to have a treatment or something. And the decisional capacity decision can be very complex and involving speech therapy and ethics team and blah, blah, blah. So when I'm working with people, and this may be to counter to what you just said, Cynthia, I recommend that they say that the medical power of attorney form is effective upon signature, because that way the doctor's not going to stand over you and ask your medical power of attorney what to do with you if you're perfectly capable of answering the question yourself. They're not going to override you. It doesn't happen. So
Right.
it does allow for easier flow in the actual hospital setting, that the power of attorney can step in, even when it's just like I came out of surgery and they're on morphine and they can't, they're non-decisional at that moment, but a decision needs to be made. They can easily turn to the power of attorney without having to go through the decisional capacity process. So that's my 3 cents.
And that's why every situation is unique. And that's why the more you have clarity on your situation, how you want it to work, then when that crunch time hits, you've got your game plan in place for people. It makes such a difference.
Okay, I'm sorry that I kind of
Oh
jumped.
no, that's a wonderful add-in
Get
because
back to your agenda here.
no, that's the practical application because it's not just words on a piece of paper. I mean, you've got that, but then you have to implement it, and the implementation sometimes can be tricky. And so that's a great point, Sue.
Okay, carry on.
Okay, so probate in Colorado, it can cost $37,000 or more. It just depends. And what does it depend on? It depends on if there's challenges to the estate, if there's missing heirs, what the assets are, where those assets are located. So it can be quite costly, or it can be not so costly because it's very streamlined. Everybody gets along. So what I always tell my clients is you can either spend the money now, get all your documents in order, or I'll see your family after you're dead because then we'll deal with the probate. It's one or the other. But one way or the other, just the more you can get done, I just urge you to please get it done. Next topic I want to talk about is conservatorship and guardianship. So the best way I like to describe it is money and health and welfare. So a conservatorship, that is a legal proceeding where the court takes away the protected person's rights. And let me see if I can move this down a little bit to manage and protect their assets. So that is what a conservatorship is defined as. A guardianship, again, another legal proceeding where an individual's civil liberties are taken away and given to a guardian to make decisions about the ward's health and welfare. So when you have conservatorship authority, that's evidenced by letters of conservatorship, and there's an order appointing the conservator. And as I mentioned earlier, you can designate within your durable power of attorney who your conservator should be and who your guardian should be. So that's already laid out. The terms of a conservatorship are usually, they may be limited in duration. It defines what that scope is of what they can all do for the different assets. It will also define how involved the court will be on that conservatorship. And a conservator has to file an inventory, a financial plan. They have to file an annual conservator's report. After they are appointed, they have the authority to take title to the protected person's assets. They then have the authority to take control of their financial affairs, and these assets are then called the conservatorship estate. When you are a conservator, you have to disclose that you are a conservator and that you have this protected person relationship with a conservatee. You're encouraged to sign your title as conservator after their name. So like John Smith and then Susie Smith as conservator. The accounts get retitled, so it's your name, Susie Smith as conservator for John Smith. Once you have control as a conservator, you have the authority, as I mentioned, to manage and administer all the assets for the protected person's benefit. So that's going to be their, all their real estate, all their accounts, whatever is defined within that order that the court gives you. The conservatorship does terminate when a protected person regains the capacity to manage their financial affairs, when the protected person passes away, when there's their death, because then it's the assets then get managed in probate, or if it's in a trust, or if there's a resignation, a removal, or the death of the conservator, or if there's a date set by the court. So after the protected person passes away, the conservator must ensure that the delivery of the assets go to the personal representative of the estate for them to take care and manage that estate for the deceased person. They have to file the termination documents with the court and all interested persons, and that might be the heirs that would inherit something from the protected person that passed away. So when you are a conservator, you have a lot of duties. You have a fiduciary duty to that protected person, and you must act in their best interest. You cannot enter in any transactions where you're going to benefit. So if there's a great real estate deal where you're going to make a lot of money on it, because you got a piece of it, that's not going to happen because you do not want to get in trouble with this. You want to make sure that you keep those conservator assets separate from your own, and you want to manage them just as a prudent person would. And you may need a fiduciary bond. And that sometimes can be costly and they're hard to get. So that's kind of a word of caution on that. There's administrative duties when you are a conservator. There's JDF Form 882, and what that is within the Colorado court system, when you go on, if you do a search for state of Colorado courts, there's forms, and then they're called the JDF forms. So there's forms for probate, forms for conservatorship, guardianship, all the forms that you might need to go to court. Summons and complaint, they're all draft forms there that you can utilize. JDF 885, that's another form that a conservator has to file, which is a conservator's annual report. The conservator needs to make sure that they're doing an accounting and taking care of all the numbers so that everything is listed, everything's taken care of, and everything's accounted for where it's coming in and what's going out. You want to make sure that there's trust asset management and that there's growth in those trust assets and distributions to or on behalf of that protected person, because you're in charge of taking care of their financial nest egg to make sure that you're the one taking care of the money portion for them. Important notes: if you are a conservator, there is personal liability if you're directly at fault, if you're grossly negligent, or if you're acting criminally, liquidating stuff that you should not be doing. And in order to protect themselves, some conservators carry that errors and omissions insurance. You are entitled to reasonable compensation and reimbursement for out-of-pocket expenses, and it's determined by a case-by-case basis when you're a conservator for someone. The compensation is taxable income, so you will have to pay taxes on it, but you can hire attorneys and accountants or other advisors to help you manage those assets. So what's guardianship? Guardianship is another legal proceeding where an individual's civil liberties are taken away and given to a guardian to make the decisions about the ward's health and their welfare. So the guardianship authority is granted through letters of guardianship, an order appointing the guardian. It again can be limited in duration, scope, and level of court involvement. It requires an initial guardian's report, that care plan, and an annual guardian's report that have to be filed with the court. So when you are a guardian, you have a fiduciary duty to the ward. You need to always act in your ward's best interest. You have an undivided loyalty to that ward and avoid your conflicts of interest. Include the ward in decisions and encourage self-sufficiency. So talk over those decisions with your ward as to what is happening and see if they can give you some feedback on things. When you're in that guardianship position, consider their ward's known wishes and personal values. For instance, somebody might want to make sure that they attend religious meetings. Maybe they want to go to mass. Maybe they want to go to church. Or maybe there's groups that they want to go to wherever they're at, whether maybe it's the Mahjong group that they want to go to or something, but always keep those in mind when you are that guardian. And you may also make some decisions regarding the ward's assets depending upon what is laid out in your guardianship documents. And you may need a fiduciary bond if you are a guardian. Your administrative duties, as I mentioned before, you're going to have to file reports with the court, that initial care plan and an annual report, which is JDF 850. These reports are due on time, because if you don't file your reports timely, you're going to get in trouble with the court. You have to make sure that there's copies to all people who are interested. There is accounting and taxes that need to be handled if this is not handled by someone that's appointed as a conservator. And you need to make sure that you're making the distributions to your ward. Personal responsibility. You could be personally liable if the relationship is not disclosed that you are the guardian of someone. You could be found directly at fault. You could be grossly negligent when you're doing something, or if you're acting criminally, that could come back to haunt you. You are entitled to reasonable compensation, reimbursement of out-of-pocket expenses, and this is all determined by a case-by-case basis. You want to make sure that you've got good record keeping and good accountability. Your compensation, if you are a guardian, is taxable income, and you may hire professionals to help you when you are a guardian. So, with all of this being said, when are you at risk? And I always tell my clients, I have clients that come in and I say, well, when did you do your will? Oh, 2000. I said, oh, you may want to think about updating it. So generally the rule of thumb is if it's been 3 years since you've updated, after you've had maybe a major life change. That could be your spouse passes away, you get divorced, things like that. If you don't have an ongoing relationship with an attorney, get one established and get someone that can kind of help guide you through this. Um, if you don't have an inventory of your assets, that's that's a huge thing because it's so sad to see families waste money on attorney's fees when they could it where the attorneys are searching and searching for assets when all they needed to do was the family had a list from the person of all the assets. And coordinate across the planning across the generations so people know what's happening. Talk about things with your family. If there's new grandkids, maybe there's children that are adopted that need to be included. Or when there's a death in the family, to get everything updated to make sure you've got, as I said, everything taken care of, stuff moved around. You might have the property, joint tenants with rights of survivorship. Well, one has passed away, and now what are you going to do when the survivor spouse passes away? What do you do with those accounts? Getting those retitled? Who are they supposed to go to? So these are all a lot of things where you might be at risk. So a really good resource if you're looking to explain in more detail on all of this, the Colorado Bar Association has something called the Colorado Senior Law Book. And I put the link in here, and I want to say it was pretty reasonable. It was like $25. And they have so much information in there, and it's just great legal information for aging adults, us blue hairs, as they like to call us. They will go through like Social Security benefits, Medicare, powers of attorney, grandparent custody, visitation, nursing home issues. So it gives you a great starting point to kind of start digging in more. Even if you're not ready to go see an attorney, it's a great way to get some of those questions answered. Or maybe as you go through it, you've got more questions that come up. So when you go to the attorney, you can maximize that time. Sue, do we have any more questions?
We do. Good timing.
Awesome. Okay.
Question of who determines the necessity of a fiduciary bond for either conservatorship or guardianship? And I'm going to throw in, I personally am confused with if you have a medical power of attorney and a financial power of attorney, when is it necessary to move that into this formality?
I'm going to say it depends, Sue.
Okay.
And more than likely, it's going to be the court that's going to determine whether or not there's a fiduciary bond that's going to be required. I think part of it's going to be determined upon the amount of assets that are there to manage. If it's a significant block of assets, the court might want to make sure that there's a bond posted to make sure that there's something put up so that you've got skin in the game on things, so to speak, if you're a conservator or guardian.
Mhm. Well, so just on a practical, hands-on situation, how would the courts even know that somebody's medical power of attorney was not adequately caring for the person and that they needed to go a step further into guardianship, et cetera?
Usually it might be that somebody files a matter with the court to have a conservator appointed or guardian appointed. And so there's a court hearing on it
Mhm.
where maybe there's a child that doesn't believe that the other sibling is not taking care of things appropriately, where they might have the medical or financial power of attorney for the parent. And so they're concerned that there's funny business going on. So they might file something with the court, a motion with the court or a matter with the court to have the court decide what needs to happen in those circumstances. I don't do the conservator and guardianship work. I focus right now more on the wills and trusts and the probate. But there are attorneys out there that do focus on that. There's also attorneys that focus specifically, another area that's very timely is the Medicaid, to make sure that you're planning appropriately if you're going to need to utilize Medicaid. Some people have long-term care insurance, and with long-term care insurance, there's a couple things that go into that. Number one, there's usually a wait period before it's going to kick in if you have long-term care insurance. And two, they figure you're going to die within 2 to 3 years. And so what happens if you're like my mom? My mom's going to be 93 in October, and her long-term care insurance ends up is done in January. So there's longevity in my family. So what happens past that point, if you're going to need to do Medicaid, or if you don't have any long-term care but you don't want to lose the house, there's attorneys that specifically work in Medicaid planning. I've not quite moved into that, but there are referrals I can give to people if people have questions or are looking for that type of advice.
Oh, yeah, that's, thank you for mentioning the, yeah, Medicaid spend down. That's important to plan for.
Yes,
And quite the specialty, I believe.
it is. It's yeah, I'm not quite ready to take that leap. I'm happy in my lane that I'm in right now.
Can't do it all. Someone's asking how often this handbook is revised.
That I don't know, but right now they've got 2025, and actually that's what I've got on my desk.
That's quite recent, actually.
Yeah, which
Um,
isn't too bad.
Right. And then last questions are, when do you need a trust, and will having a trust avoid probate?
If it's repeat those one more time, Sue.
When do you need a trust? And the other question is, will having a trust avoid probate?
If the trust is properly funded, it will probably avoid formal probate, but you might need to just do informal probate, which is a lot cheaper. Having a trust, it depends on your family situation and what you have for assets to pass down and what you want to pass down and how you want those assets to work. Some people uh, have responsible kids that if they get an inheritance, they know they're going to be fine. They know they're not going to waste it. They're not going to go to the casinos. They're not going to go on a trip around the world. Some parents may have children that that's not the case, and so a trust might be more appropriate. One of the things that you can do within a trust is what I call my ages and stages language, where you might dribble out money at certain ages. So, for instance, when I have families that have young children, there might be a certain amount of money that comes at 18 because they're going off to college, or there's money. I always put in the HIMSS, which is the health, education, maintenance, and support for award if they're getting money out of the trust. And then maybe they get money at 24 after they're out of college, money to help with the house or help with a business. Or maybe they're not going to college, but they're going to a trade school, so they get money then. And then with the ages and stages, you can determine, just getting it at certain times. Or if there are the drug and alcohol issues, maybe there are stipulations or requirements that they have to be clean for a year, or they have to do something in order to get that, because you want to make sure that they're going to be responsible with that inheritance. So it's really a decision that you need to sit down and talk with the attorney, because I have some clients, a will is perfectly fine because it's just going to pass and it's not an issue for the heirs. But then I have other families, because of their circumstances, a trust is more important. And another great example is, there was a family that it was a mom and dad, and they had 3 million is what they had for their estate. And they just had one child, and they just did a will, and it went to the child. Well, the child was driving and inherited the 3 million, got in a car accident. She wasn't at fault, but there was a daycare van that ran a stop sign. There were a few people killed, and what happened was all of it went, and she had nothing. And if they had set up a trust, that may not have been the situation at all. So it really depends on your unique family situation. And it's best to sit down and talk with your attorney on it and see what really works well for your unique circumstances.
Okay, thank you for that.
Mhm.
There's no other questions in the chat for the moment, but I wanted to ask personally, can you talk about POD accounts as a way of avoiding probate?
Yes, if you do have that, that is a good way to avoid probate because, like I said, I had one client where husband didn't have a will and the house was held, the title in it was joint tenants with rights of survivorship. So the wife got the house. Then all the accounts were payable on death to the wife. So she got all the money. So with that, we could do informal probate on it. So it didn't need to have the extensive. So informal probate, pretty much what you do is you've got a person is named as personal representative. In this case, the husband didn't have a will, so we named the wife as a personal representative. Then you needed to do a notice to creditors. And what that is you publish in a newspaper 4 times that this person passed away and does any creditor out there have a claim? Then you have to wait 4 months. And once the 4 months have passed, that there are no claims made, then you can close it. So an informal, if there's no property less than $86,000, everything got distributed because of the joint tenancy with rights or survivorship and payable on death. It's not the extensive that you would need with probate. Now, the one issue that you may run into with the payable on death on the accounts is um, how willing is the bank or the insurance company willing to part with their money? For instance, I had another client, her mom had set up, payable on death to her daughter, and she was the only one that was going to inherit. It took her months to get the money because the financial institutions just did not want to release it. So again, it may work and it may not. It just really depends. And the other thing too to keep in mind, to back up on powers of attorney, is also check with your financial institution with the power of attorney that's drafted with your attorney if that's going to be acceptable. Because sometimes some institutions, your attorney does a wonderful job, gets that financial durable power of attorney all drafted up. You get it, you've got it in your binder. You go to the bank and the bank says, yeah, not good enough. We got to have something else. Or it needs to go to our legal team to take a look at and review. So that's another thing to always make sure is that it's going to be acceptable for your bank. Some banks will take them, some have to have their certain forms. It just really depends.
Thank you for confirming that. We had, when one of my parents died, my brother was executor and ran into that fairly frequently as someone
Yes.
closed out my dad's accounts, that we had all the paperwork, but the bank's like, no, 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 it has to be different paperwork. And it just dragged everything on longer and longer.
We
My
call that bring me a rock.
bring me a
So
rock.
bring me a rock, not that one. Bring me another rock, but you don't know what rock you're supposed to bring.
Right, right. Um, Sadly, I tease people myself when I don't do obviously legal advice, but when we're talking about choosing your people to represent you and such, that you might want to choose for your personal representative or executor. It's a perfect opportunity to kind of get even with somebody that
Yes and no.
you got a grudge with, because it's not a very pleasant job for the most part. Um, let's see here.
It's a lot of work.
Yeah, it can be a lot of work. Marla says, yes, as a former banker, always better to present the document before you need it to confirm. And we've got one more question. I don't have children and have 2 real estate properties. Will a transfer on death be sufficient? Transfer on death being the same as a POD, right? Correct?
Not for the properties. What you could do for those is you can draft a beneficiary deed of who it goes to upon your death. Um, I have not done those yet, so I really can't advise on those, but that is an option on those type of properties. I would I would run it past an attorney and get their best advice on it.
Okay. Um, okay, I am not seeing any other questions that haven't been answered. Do you want to open it up to live questions?
Sure, let's go live.
Okay. And maybe, I guess you could take your screen share down
Okay,
if you
hang
would,
on.
and then we can see everybody.
Oh,
And,
I got to show you the last bits though.
oh, is there more? I'm sorry.
There is. So talk with an attorney. Overwhelmed? No worries. Talk with your attorney to understand your situation. Get your belt and suspenders on. And
Okay.
Lacey the
Oh,
cow.
oh, oh, this is one of Cynthia's actual cows. She's
Oh,
adorable.
okay, now I can take it down.
Okay.
Oh,
Thank you so much, Cynthia. That was great. So folks, if you'll use the raises hand
oh,
thingy
where
on the bottom of the screen,
on
and if
the
you've got a question,
bottom?
and
Huh.
then you can unmute yourself to ask your question. You got free legal advice right here.
But I am not your attorney.
Right. Well, yeah, there's always the
I have to
disclaimer.
caveat that.
Okay, I'm not seeing any hands raised at this point. I'm going to throw out a question on, can you speak to holographic wills?
I've not had to litigate those. I don't recommend those. It's interesting. I've got one going through probate right now where
Will you define holographic will to everybody, just in case they don't?
so a holographic will is basically a handwritten will, and it's probably not notarized, it's probably not witnessed, and it's may not hold up in court. So I would definitely not recommend that. I've got a couple situations that I'm not handling, but I'm aware of with actually my own brother-in-law. He passed away earlier this year, and we helped my other sister and I helped him to get the will drafted. But unfortunately, my nieces didn't get it witnessed or notarized. And so we've got this document kind of sitting there. So he's intestate right now, and there's real estate. So hopefully they work it out. It's in North Dakota, and I'm not licensed to practice there.
Okay, thank you for that. Yeah, I guess I learned that holographic will was an old mining law, for the miner who just hit gold and he needed to scribble on a napkin or something, his will, in case he died before he got to spend all his money. Stephanie.
Hi, yeah. Well, thank you so much for all this information. I'm writing it down. And I actually have been recently given the name of an attorney. I'm in Colorado Springs. So I think you've kind of prompted me to I need to take care of this. I do have a question though. All those documents you listed, is there a special document where where you talk about I'd rather be have a natural burial or I want to be cremated or kind of those final disposition? Is there a document for that?
Yeah, typically what I provide to my clients is what's called a remembrances and services memorandum, where I just let the client fill it out of how they want, if they want to be buried, cremated, if they have a funeral home, if they have a funeral plan, if they have a plot, because you want to make sure your kids know about that. Because some people, we get to Colorado and we might have a family plot in another state and it's all paid for, and you want to make sure that they know about that. Who you notify in case of your death, professional organizations. So, kind of a mini obituary that people put together. But I supplement that with what I call my remembrances and services memorandum for the client to just fill out at will.
That's a
But
great.
is that something then you have notarized and things like that, or how does
Um,
people know that that's around?
um, I would keep it. I tell my clients because I always put it in their binders, and I tell them to, let your family know what you want to do. Because I actually do talk about that with them. What do you want to happen with
Mhm.
you? So that you got those options. And Sue, don't we on the Funeral Consumer Society of Colorado have kind of options of how people can be taken care of, like burial, cremation,
There's a lot,
green,
yeah, there's a
etc.?
lot of information on our website around what our
Yes.
options are. And we have our YouTube channel, which if you get on YouTube and search for Funeral Consumer Society of Colorado, you'll find some of our previous webinars on different options, body disposition options. But Stephanie, there's also a Colorado document that you can find online called the Declaration for Disposition of Last Remains.
Okay.
And with that document, you can assign the person who is the one who will make your funeral decisions for you. As in, you take the document to the funeral, they would take the document to the funeral home and say, here, she said that I'm the one.
Underreact.
It isn't necessary for everyone, because most of the funeral establishments generally have their what's it called? They have an order that, like, they'll talk to the spouse will make the funeral decisions, or the kids. They go through the family hierarchy of who would be the decision maker for making your funeral plans. But if you don't have a spouse and you don't have kids,
I don't have any of those, so yeah.
right. So the Declaration of Disposition of Last Remains is a helpful form to at least assign a friend or another relative or some. So
Great, thanks. I do have these documents, but they're like 20 years old, so I think I just need to update.
yeah, always good to update, as Cynthia said, anything that triggers you, including just a period of time having gone by, but definitely, there's 5 Ds, right, Cynthia? Divorce, death, a diagnosis, a new decade, and I never remember the 5th D, but those are like triggers for
A new haircut, a new do.
I need to. There you go. Kim, did you want to ask your question? Go ahead and unmute.
There we go. Can you hear me?
Yes.
Oh, good. Okay. Hi, Sue, and you've helped me before. So, but I just wanted to follow up on my question about, I've got a property in Vermont and my home here in Colorado, and I understand that a transfer on death is a way to do it. I don't have kids. It's just going to go to one person. One person gets one thing and the other person gets the other thing. So pretty straightforward. And then I know I need to have it authorized, notarized, and also recorded with each township. So would that be sufficient to keep me out of probate and, be able to, get the properties to who I want them to go to?
I can't give you any advice on the Vermont because I'm not familiar with Vermont. I'm not licensed in Vermont, so I can't provide any advice on that. You might be okay with the Colorado property if it's properly recorded with the beneficiary deed. Is that what you're talking about?
Yes, that's it.
Yeah, the beneficiary deed. There's some requirements of what needs to get done, so I would definitely sit down. One of the things that's really important that I always do with all my clients when we're going through that will, when we're going through the trust, I always order what's called an ownership and encumbrance report. And you're asking, well, what's an O&E? An O&E is a listing from the title company that tells you what is the vesting deed, how title was taken, so you make sure you're conveying it to the right, from the right entity into the trust, or with the will, or with the beneficiary deed. And then you're also seeing if there's any outstanding debts, liens, mechanics liens, etc. on it. So you always want to make sure you've got, like I said, all your ducks in a row as you're doing any of that transfer. So sit down with an attorney, make sure that everything's properly drafted, and then you'll be good to go.
Okay. And so I wasn't going to do a will. So I didn't think that, because I've all of my investment accounts, I have beneficiaries, TODs.
Mm-hmm.
And so these two pieces of real estate are really the only other things that I have that are really of value.
I would still recommend that you have a will just in case you win the lottery between now and death. It just makes things tidier.
Okay. All right. Thank you.
Mm-hmm.
Appreciate that. Yeah.
Cynthia, we got a few more questions here. Do
Okay.
trusts help against lawsuits while you're still alive?
Um, I've got various thoughts on that. It, I'm going to give you the lawyer answer. It kind of depends. Because if it's an irrevocable trust, you've got better protections on it because you don't have control over those assets. Someone else does because there's a different trustee. The revocable trust might get penetrated, and might be used for lawsuits because you do have control over those assets. So it really depends on what's going on in those circumstances.
Okay, thank you. And there's a couple of different questions around how do you find an estate planning attorney in your area that's reputable?
Um, so one thing you can do is you can actually go on the Colorado Bar Association. I think there's like for the public to find an attorney, and you can take a look and see, who does estate planning in your area. And then you can, do a Google search, see, how they're ranked, how people have liked them. If they've got 5 stars or somebody says, stay away, don't go to them. Or, sometimes you'll see we have like the super lawyers or lawyers that are voted by their peers that are high, and you'll see that. So that might be a way to take a look at it. But I would go on the Colorado Bar Association, or if you've got, friends or neighbors, talk to them and say, hey, who have you used? Did you like them? Just like you would figure out who's a good roofer or someone to do the painting on your house. Word of mouth is always a great way to try to find out. And I'm sure if you're on Facebook, post, hey, who recommends a good estate planning attorney? You'll get a lot of information with that.
Do you have any suggestions for how to interview an attorney? If you're making calls, you've got a list of 3 or 4 people and you want to narrow it down. What kinds of things should you be asking?
I would ask them, how long they've been in practice, how long have they done estate planning, what, if they have an area that they practice in estate planning, they have older clients, do they have younger clients? And ask them about, what, what's your most interesting case that you've had to do? Do you do probate? Because some attorneys, so an interesting thing that I learned about today, there's attorneys that do estate planning and attorneys that do probate, and there's a business model out there where you're just doing strictly estate planning. And then there's a business model out there where attorneys will do estate planning and then they make their money on the probate. I found out in California, that's where the attorneys make their money because they make their money based on the price of the overall estate. So you might want to ask them, how do they charge? What's all included? What if we need to make changes in it? How long you're going to be around? Are you old? Are you young? Are you going to, their succession planning, questions like that.
Yeah, I've had people tell me that they've gone to contact their attorney to revisit their will and or trust and found out that they've died. And they can't, like there was no plan. They can't access their original paperwork and such. So yeah,
Yeah,
asking for the succession plan, it seems like a really good idea.
yeah, because it's interesting. So when I actually formed a law firm and that attorney died, I had to close up all of his files. So I had to, track down the plans. Good thing that there wasn't a lot of open cases that he had, but, asking them what their succession plan is. Another thing too is what I always give to my clients is when the documents are all signed, I scan them in and put them on a thumb drive. And so the client's got the originals and they've got the thumb drive. So, having duplicates, whether in other locations, so maybe you give a thumb drive to your children or to somebody else to hold. Another thing, if you've got a safety deposit box, here's a tip when you've got a safety deposit box. Have your child, also be, on the safety deposit box to sign to go in, but just tell them where the key is. Don't give them the key so they go in there, but let them know where the key is at. But that way they can get into the safety deposit box and you can keep your documents there. Or fireproof safe, that's another way, especially here in Colorado with wildfires. I mean, you just never know when they're going to roll through. So,
Just don't put your medical power of attorney form and your living will in the safety deposit box.
yeah, that's a bad thing.
It will not be accessible on the weekends, in the evenings, and blah, 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 when you need it. So make sure that your agents, your healthcare agents all have
Copies of it.
copies, yeah.
Yeah.
Here's another, we've got 5 more minutes.
Okay.
Can an attorney become a personal representative? And if so, what would the typical cost be?
They could, but there might be a conflict of interest on it. It would depend. I'm not sure I'd want to be a personal representative if it was stuff that I drafted. If it was something that somebody else drafted, I would do it because if there's questions on it, you could become a witness in it, and that just gets messy. Usually for when it goes through probate, it's an hourly rate. That's what I've been saying. There's a retainer that you need to provide for the attorney. I've kind of learned the hard way that I get retainers up front because I've been burned one too many times.
Okay. And Elizabeth is asking, do you need a local attorney or just a lawyer licensed in Colorado?
It depends what you feel comfortable with. So as I mentioned, I'm up here in northwestern Colorado, but I actually have some clients on the Front Range. So with some of them, when we put together their plans, I've met with them on Zoom, gone through all the documents, and then I drive down to the Front Range and I tell them, you bring the witnesses, I'm the notary, and we'll get everything signed. So it depends where you feel more comfortable.
Okay, great. And I think that's, if I've missed someone's question, will you raise your hand and jump in person and let me know that I didn't see it? Okay. In the last couple minutes, I just wanted to bring up property memorandums. I've looked at people's paperwork and again, not with legal eyes, but just to see that they have it. And 90% of the time, the personal property memorandum, that's the back page of your will, is blank. And I personally, I just want to put a plug in for writing your personal property memorandum because it's actually a really enjoyable exercise to sit and make a list of all of your stuff that's not covered by your will, because the will's covering the financial stuff, but your personal property things that you might like to see go to your specific grandchildren or children or friends or whatever. You can sit and make that list and maybe a little story about the thing and why you want to give it to that particular person. And it's a real feel good thing to do. And you feel like you're giving all your stuff away, but you don't have to really part with it yet. So, but Cynthia, what's your experience with people actually completing that aspect? And mention also that it doesn't need your expertise or notary or anything like that.
Yeah, typically what I do is that's another supplemental document that I'll give to my clients as a personal property memorandum for them to fill out at their leisure. And I always put it in Word rather than Adobe so that they can make changes to it because things change. You get things, you get rid of things. But I always recommend people do that. And another thing that I also recommend for clients is write a letter to your family. Maybe you've got some specific wishes, something specific, those pearls of wisdom that you want to pass down to your children or to your grandchildren. And then another thing that we just didn't have time to talk about, and because that's a whole nother session, and that's guns. When you have guns that you need to pass down to children or pass down to relatives, there's gun trust. That's a whole different area that there's just not you got to have one full session on that.
Wow.
But
Okay. We're just about right at 5:30. Cynthia, is any closing remarks?
just get her done. Nobody wants to think about the mortality, and people think there are the superstitious people that think, oh, if I get my will done, I'm going to die. You're not going to die.
No.
You will get it done, and you're going to make it easier for your family. Unless you don't really like your family and you want to just leave a big mess, then go ahead and that's what you're going to leave. But your wishes may not be followed, but just get it done.
Yeah.
You either see the
Well,
attorney now or you see them later.
well said.
Family sees them. Yeah.
Cynthia, thank you 1,000 times over for this great presentation. It was super informational. Everybody here and anyone who's on the Funeral Consumers email list will get a recording of this program in the next several days, as soon as we get that all formatted. And just going to wish everybody a good evening. Thank you for supporting the Funeral Consumer Society by attending.
All right. Thank you, Sue.
Have a good night.
All right. Good night.
Bye now.
Thank you.
Mhm.